It seems like the trend is continuing with lawsuits on nonviolent misdemeanor and felony charges, whether or not people should be able to own firearms. We've got another one out of Pennsylvania. Let's talk about it. Hey everybody, welcome back to the channel today. That's right, we've got national implications already in January 2025. The year is just getting kicked off, but we're seeing some carryover from last year that's definitely worth talking about. To do that, we have brought back Kostas Moros. He is an attorney at Michelle & Associates. He's really been leading the charge on the CCW front here in California. Kostas, thanks for coming on with us.
Oh, it's a pleasure, Kevin. Thanks for having me on.
Absolutely. And I guess we can just jump right into it here. We got this from thetruthaboutguns.com. Jacob, if you could actually pull this up, the article, it reads like this. A Pennsylvania man who pled guilty to food stamp fraud back in 1995 got a great Christmas present 2 days early. Brian Range had been denied his right to keep and bear arms for nearly 30 years, but on December 23rd, the Third Circuit Court of Appeals reaffirmed its earlier ruling that person who commits a nonviolent, non-dangerous misdemeanor and hasn't been incarcerated cannot be deprived of his or her Second Amendment rights. Range's conviction was classified as a Pennsylvania misdemeanor punishable by up to 5 years imprisonment. Since the federal law generally makes it illegal for anyone convicted of a crime punishable by imprisonment for over 1 year, Range wasn't able to process or purchase a firearm. In June 2023, the Third Circuit Court of Appeals restored Range's rights to keep and bear arms, but because of a circuit court split, the case was sent to the U.S. Supreme Court, which remanded the case back down to the Third Circuit. The latest decision sends the matter back to the Supreme Court for consideration. The pre-Christmas court ruling stated, Range remains one of the people protected by the Second Amendment, and his eligibility to lawfully purchase a rifle and shotgun is protected by his right to keep and bear arms. So, I guess seeing this, I mean, this one's coming out of Pennsylvania. We saw a court case that sent shockwaves through our community back in July of last year. That was U.S. versus Duarte. And I actually, Kostas, if I remember correctly, I had you on to talk about that case where we kind of went over it. But for those of you who don't remember, the U.S. versus Duarte case wasn't even dealing with misdemeanor, and it was out of the Ninth Circuit, but it was dealing with nonviolent felony charges where they ruled that Second Amendment rights shouldn't be taken away from those individuals. I guess, Kostas, what I'm curious about is now that this is going back to the Supreme Court, does this become sort of a focal point of Second Amendment litigation for 2025?
Yeah, so there's basically three baskets of Second Amendment cases right now. There's the hardware cases, so the magazine bans, the pistol rosters, assault weapons. There's the where cases, which are the sensitive places cases, where you can carry. And this is in the last category, the who cases. So who has Second Amendment rights? And the issue presented in this Third Circuit case, Range v. Garland, is about somebody who was convicted of a nonviolent misdemeanor 30 years ago in 1995. It was basically his family was struggling and he overstated his income to get food stamps. Now, remember, even though it was a misdemeanor, federal law is actually written such that if the crime is punishable by over a year in prison, I forget if it's 1 year or 5, the article says 1 year, so I'll go with that, but it might be 5. I'll have to check after. But if the crime is punishable by over that certain amount of time in prison, even if you don't get that punishment, you actually lose your right to bear arms. So even though this is technically a misdemeanor, at least it was, at least that's what the article says it was punished as, and the case in Duarte was a felony, it's actually the same federal law at issue. Duarte might, I forget if it also involves the marijuana aspect, but both cases deal with a nonviolent felon or would-be felon had he been charged as such. And now both cases reach the same ruling. Now, Duarte, of course, is en banc. So there was already oral argument en banc because like all gun rights wins in the Ninth Circuit, it got en banc review. And it seemed like the oral argument went okay, and it's a very close panel. It's 6-5 ostensibly against us, but there's at least some chance that one of those 6 normally hostile to gun rights might be sympathetic here to a nonviolent person. We'll just have to see. But it's actually okay if the Ninth Circuit rules against Duarte now, because it'll just add to this circuit split. So the Supreme Court's going, now that we have at least one circuit saying this, and they did say it before Bruin, but now they've reaffirmed it and actually added to the majority because one or two dissenting judges actually switched sides on the result here in the Third Circuit. That means that the Supreme Court can't really dodge this issue anymore. It'll probably have to be taken up either next year or the year after that.
I've kind of experienced, at least myself, in a lot of communication that I've seen, a little bit of a mixed bag of emotions in reference to the Duarte decision back in July. I feel like there's a lot of programming out there for people to that can potentially put all criminal activity under a single umbrella. Perhaps, we're kind of programmed to think criminals are bad. However, this isn't necessarily reflecting that when we're talking about rights. I'm wondering, can you explain the argumentation a little bit that's going on in court? Is this simply just about violent versus nonviolent criminals that we're talking about when we're talking about restoring Second Amendment rights? And what's the argumentation there for these people being able to retain these rights?
Sure, it shouldn't really be controversial, in my opinion, in either case, because yes, the main distinction. So the first question they ask is, and the Third Circuit went through this analysis, is the person part of, quote, the people, the plain text of the Second Amendment? Is this person part of the people? And in my opinion, that answer should always be yes, unless we're talking about like an illegal immigrant or something, which arguably might not be part of the people. But usually, even a violent criminal is part of the people. But then you go to the historical analysis and you say, is there a historical tradition supporting disarming this person for this action? And that is where violence and dangerousness matters. So if this person has been established to be dangerous, then that's a different analysis. That means that, yes, there is historical support, as the Supreme Court talked about in Rahimi and other cases, that there is historical support for disarming, sometimes temporarily, sometimes permanently, violent people. But Mr. Range, he committed his crime in 1995. He didn't even go to prison, but he paid all the fines and the restitution. And he's had, other than some traffic tickets, a clean record for the last 30 years. And actually, one of the formerly dissenting judges switched sides on this issue. He concurred in the judgment, even though he disagreed with the majority's analysis. But he said, look, this federal law on felon disarmament was supposed to have a provision by which people could regain their rights, but Congress basically hasn't funded it. So normally a felon should be able to petition and say, look, I've had a clean record for so many years. It's time to give me my rights back. I've been a good citizen. But basically that's been it hasn't existed, even though it's supposed to exist. And that judge said, I'm basically going to treat this as a petition by Mr. Range to restore his firearm rights, and I find that he's not dangerous, so I concur in the judgment. And so he reached the same result through a different avenue. And I think that's what you have to look at here. And remember, one of the rulings on this, I forget if it's the 8th Circuit or the 10th, but one of the courts to look at this basically said, well, Congress can call, if Congress says someone's a felon, then, there's historical tradition supporting categorical disarmament for felons. But the problem with that is that we've greatly expanded what felony means. Like, you can make anything a felony if the government wants to. And they've also disarmed other categories of people, not just felons. Like, you smoke marijuana, which in a lot of states is now legal, and you lose your right to bear arms. It's preposterous. And that there's a different family of cases on that issue, which the Supreme Court might have to rule on separately. But yeah, I don't think people should look at this as bad people are going to get guns. Bad and violent people who have shown that their dangerousness can still be disarmed. That's not at issue in these cases. What's at issue is whether non-violent felonies should mean permanent disarmament.
Yeah, and I like the way that you stated it there, or at least the way the analysis is done. Is this person part of the people? I think certainly, there's opportunities in life for people to make mistakes. You can draw a hard line in the sand when there's evidence supporting that somebody is a danger to others, which would infringe on others' rights. But with something like this, the argumentation seems to be, is this person part of the people? And I think that's a good line to draw in the sand as well. I'm also curious, what are your thoughts on California being an exporter? Again, kind of going back to the Duarte case. You know, we often talk about how California is a huge exporter of bad legislation and bad laws into all of these other states. With some of these legal opinions coming out now, when do we start saying that California or the Ninth Circuit is also kind of a good exporter of good legal decisions?
Well, they'll have to start making some first, right? But there have been some good rulings, like the Duarte panel ruling. But again, that's been being reviewed en banc now. So we'll see if we get a good ruling or a bad ruling. But like I said, I'm not losing too much sleep over it, because even if it's a bad ruling, it just deepens the circuit split and forces the Supreme Court to have to take the issue. But yeah, California. We'll have to see. For example, if we get a ruling on one of the cases I work on, high fees and wait times, if we get a good ruling there, either from the district judge or if we have to go to appeal, that could be very persuasive, because when you have even the Ninth Circuit ruling something unconstitutional in the Second Amendment sphere, which they hate to do, that's pretty strong persuasive authority everywhere else. I think another good example is Nguyen v. Bonta. It's not one of our cases, it's one of FPC's, but we did write an amicus brief in their support. And in that case, you had a 2-to-1 Democrat-appointed majority panel lift the stay on the 1 in 30 rule, pretty much implying they haven't reached their ruling yet, but they've all but indicated by lifting that stay that they're going to rule against California and say that the 1 in 30 purchasing rule is unconstitutional. So that's going to be pretty strong persuasive authority everywhere else, because basically any other lawyer can say, look, even in the Ninth Circuit, which has a long track record of hating the Second Amendment, they ruled this unconstitutional. So if another state like New York, Colorado, whoever else tries to pass a similar law or has a similar law being challenged, it's very strong persuasive authority to show that a court that usually disagrees with the Second Amendment is ruling in its favor. So I think that's where it can be a positive.
Well, we certainly talked about some reasons to be optimistic at the end of 2024. Here we are now at the beginning of 2025. As far as you can see, since last year, which wasn't too long ago, what's the landscape looking like? What do we have to look forward to at the beginning of this year?
Well, you're going to have to ask me again in a week or two, maybe longer. The Supreme Court is the big question. And right now there's a stack of cases about to be heard in their conference on Friday or Thursday. I forget which day it is. But at the end of this week, they're going to be talking about Snope, which we've all been watching, Gray v. Jennings, another magazine case. I think it's Ocean State Tactical, but I might be wrong about that. But they've basically stacked all these gun cases on one day, which hopefully it doesn't mean a mass denial of all of them. Hopefully it means they grant at least one of them and they'll hold the others. And so we'll have to see what happens, but that could either be a great start to the new year or a terrible start to the new year if they deny the cases and we're back to waiting to see which one they eventually feel like taking on the hardware side. Because the hardware question needs to be answered, as Justice Thomas said in his concurrence when our preliminary injunction case was denied last summer. He basically said, we don't want preliminary injunction cases. However, once one of these cases gets to final judgment, which Snope is, we should answer what the hardware, what exactly the Second Amendment protects when it comes to firearms, because we've already said handguns, but now it's time to really define that. And I agree. I hope that they take the case. And, I think it's a hot issue for sure. Not as hot as, they've taken cases on abortion and other stuff that's even more controversial. So I don't think they should be scared of it. Sorry, I lost the light there for a second. But it is a controversial issue, but I hope Justice Roberts and the others, Chief Justice Roberts, are heartened by the fact that Donald Trump just won the election and there's no threat of court packing coming anytime soon. So we'll have to see what happens, but fingers crossed that we get a grant in Snope.
Well, absolutely, and those are things that we're definitely going to be following along here as the Supreme Court does go through those cases. Kostis, as always, I appreciate you coming on, enlightening us a little bit. Thank you very much for coming on.
Always a pleasure. And again, keeping our fingers crossed here.
Absolutely. And guys, if you like videos like this, you want to see more coming in 2025, if you want to directly contribute to Second Amendment litigation and legislative efforts, please, as always, be sure to like, share, and subscribe to these videos. It really helps get the information far and wide. And of course, we are getting it from the attorneys that actually work on these lawsuits. So once again, smash the like button, share it with as many people as you know. We're trying to get this information out there. Thanks again, guys. We'll see you on the next one.